Hello, everyone. Once again, my name is Massimo Capretta. I'm a lawyer in the firm's finance practice, and I'm headquartered in Chicago. Thank you for signing into our program. Before we get started, we have to go over a couple administrative items. During today's presentation, you will be provided with an alphanumeric code. If you are a lawyer and you are applying for CLE credit, you will need to record this code on the virtual sign-in sheet that you will receive by email with connection details. If you will find directions for returning that virtual sign-in sheet on that form. We will read the code in the middle of the presentation and then again at the end. Because of the length of the materials and the allotted time for the program, we aren't going to answer any questions during the program, but you do have the option on your screen to submit questions, and if you do so, we promise we will get back to you at some point in the next couple of days. This program is being recorded, as we normally do with these types of webinars. In a day or so, we will be sending you an email with a link, which you can use to listen to the webinar again and share with your colleagues if you'd like. The recording will also be posted on our website and can be reached either on the Finance Department webpage or by just accessing the biography for me or Dave Chinchillo. Along with me, as I just mentioned, is my colleague Dave Chinchillo. Dave and I coordinate most of the work in the trade receivables non-recourse area here in the United States for the firm, and we'll be doing different parts of this presentation off and on. Finally, I should mention this presentation is a follow-up to a live program we had in New York earlier in the fall. That was more general in nature. This one will be more detailed. This program is geared mostly to U.S. clients. You know, it does discuss cross-border stuff, but from the view of a U.S. participant, we're going to have separate programs geared towards European and Asian clients at some point in the near future. So please look for those. And then finally, one last item, to the extent that you're on the call and you happen to be attending the CFA annual conference starting tomorrow, we'll be there too. So, you know, if you like the program, and please feel free to say hello. We'd love to meet you. Okay, so we're just going to go ahead and get started. The agenda we're going to cover today, some background material, some background information, a little bit on recent trends, some typical documentation, some discussion of participation agreements, then accounting issues, true sale, and some foreign receivables topics. We have a number of slides, and we're going to be going through this at a fairly quick pace, and I apologize for that, but we'll try to get through as much of it as we can. Just for some background, really the focus of this presentation or webinar is on, you know, non-recourse receivables finance, which this is just a basic schematic. You know, words and terminologies obviously differ by sub-product area, et cetera, but really we're talking about this kind of stuff. So we wanted to spend a little bit of time talking about some of the more recent trends we're seeing in this area, because I think it's fair to say that there's probably been more activity in the U.S. in this area than in the last couple of years than we'd seen in a long time before then. So lots of changes. We're seeing lots of you know, new and different kind of aspects of the area, so we wanted to just talk about it a little bit. First of all, you know, the last 12, 18 months, we're seeing lots of interest in financing non-U.S. receivables, more so than in the past. Lots more interest in the market and familiarity with sort of, you know, non-historically common U.S., you know, sort of structures. You know, specifically lots of interest in note and draft type programs or facilities. We're seeing lots of interest in moving to, you know, under certain circumstances away from kind of the traditional uncommitted purchase facility more to sort of soft commits or semi-committed facilities, and that we're seeing that in all kinds of ways, by creating, short-term commitments, creating flexibility on ratings triggers, creating flexibility on pricing, so, putting in structures that change discounts and reserve requirements based on sort of performance of, individual receivables or pools. Lots of activity in that area. Also, lots of interest in financing non-traditional, just, open book accounts receivables. We're doing a lot of work recently with, more servicey type contracts, energy contracts, IP type licenses, a lot of longer term and type assets that have other issues with them that you don't typically see with open book trade receivables. Specifically, with those types of assets, there's a lot more performance type risk that needs to be dealt with. There's oftentimes regulatory concerns, and what ends up happening is the more sort of non-traditional the asset, what ends up sort of developing is the more non-traditional and esoteric sort of the solution. So at least in some of these areas, we're seeing a little bit of mixture today of sort of structures or documentation that, we're bringing back some securitization-like structures sometimes to deal with some of these issues, which is kind of funny because the reason I think a lot of people moved to this area, a lot more towards this area in the first place was that we didn't have to deal with as many of the securitization structures. And I think the next bullet point kind of summarizes kind of the whole trend is that you're seeing lots of interest in finding ways to combine, the flexibility of securitization and ABL structures with the simplicity and certainty of factoring, lots of interest in pooled facilities or batch funding type structures. And I think that's going to continue. We're getting, calls every day, trying to look at new ways and slightly modified ways of doing kind of what we were doing before. I think, and this is just anecdotal for me, I think as these types of products become more popular and have become more popular, we have seen a downward interest in sort of traditional trade receivable securitization and, traditional ABL. I mean, we're not bankers, so we don't really know that for sure, but that at least based on the volume of stuff that we're working on here, I think that's true. And finally, a couple additional trends. We've seen, at least the last year or so, a lot of interest in more regional and smaller banks, I should have said investors in this area. Historically, a lot of these types of non-recourse receivables financing facilities were done by a fairly small number of players and, mostly banks. And at least, and Dave's nodding his head across the table from me, but I think the last 12 months or so, I mean, we've really seen a blossoming of interest in this area amongst, what I'll call, what says on the screen, smaller and more regional participants. And the one thing I definitely wanted to mention this year, lots and lots of interest in credit-insured receivables, financing or purchasing, receivables backed by trade credit insurance. And just a couple notes on that. It's implementing these types of programs actually is fairly complex, and there are some meaningful true sale issues with credit-insured receivables, so we always urge people, and it's out of context of the slides, but it is an area where you want to pay particular attention on the legal side because you could fall into a lot of, sort of problems down the road that you aren't thinking about at the very beginning. So that was a very, very, very brief, hopefully, overview of what we're seeing. We're going to move on, and I'm going to hand it over to Dave, who's going to talk about some typical documentation.
Thanks, Massimo. Thanks, everybody, for joining. My name's Dave Chinchillo, as Massimo said. I'm a partner in the finance group here at Mayer Brown. There are, as most of you on this call know, a number of different products that fall under the umbrella of trade finance, supply chain, transactions. For the sake of this particular webinar, we're going to focus on, as Massimo mentioned earlier, the sort of typical receivables purchase transaction where supplier sells accounts receivable from specific account debtors to the finance provider, whether that be a bank or other finance provider in that circumstance. So starting out with one of the typical agreements, and again, this is really actually the heart of the overall facility is the receivables purchase agreement. This is the agreement that really defines the terms of how and when receivables will be sold from the supplier to the purchaser. These are very often uncommitted facilities. They are uncommitted in the sense that the seller has no obligation to sell and the buyer has no obligation to purchase. The uncommitted nature of these facilities, as Massimo discussed earlier, helps with the regulatory capital treatment, helps with the pricing, obviously, as a result of that, although we are seeing in a number of circumstances sellers asking for facilities that have more committed aspects in nature. Now, that doesn't always necessarily mean that it's a full commitment for the life of the facility, but it may, for example, be if you say yes, then you are committed for at least 5 days prior to the date that you purchase to actually purchase those receivables, and then there's variations on that theme. These transactions, and again, another fundamental grounding of these transactions is that they are limited recourse. They are designed to be true sales. That means that there is no, or part of what that means is that there is or should not be any recourse for credit-related matters back to the seller in the event that an account debtor becomes insolvent. This is not to say that there's anything wrong with a transaction that is not a true sale. There certainly are transactions that are done that aren't true sales, and there are transactions done in this space that have aspects that make them less likely that they would be treated as a true sale in bankruptcy, but they're still done because it's a cost-benefit analysis, and ultimately, as long as you go into a transaction with your eyes open, understanding what the risks and rewards are, we can structure really just about anything to satisfy the strategic goals of the various parties involved. I'm going to say also one of the other fundamental components of these transactions is the account debtor itself, and whether or not that account debtor is notified or not notified that the receivable has been sold from the supplier to the finance provider or the bank. It's interesting because in a lot of cases people would prefer that the account debtor not be notified. In some circumstances it's intended to avoid confusion. In other circumstances the supplier feels that the account debtor would be there are various terms used, right, but betrayal is one of them. Why are you selling my receivables? Or are you having financial difficulties, suppliers, that might make me look to other suppliers? That's a fundamental component of these transactions, but moving beyond that, and I'm going to skip performance guarantee for a second and go to financing statement, the fact that a receivables purchase facility is non-notified to the account debtor, where the account debtor doesn't understand that the receivable has been transferred, hasn't been notified, doesn't mean that you don't need to file UCC financing statements. Again, we're focusing primarily on transactions in the U.S. A UCC financing statement is required even in the case of a sale of an account receivable. Accounts, chattel paper payment intangibles, and promissory notes, the sale of which are governed by the Uniform Commercial Code. So it's not just collateral assignments, and sometimes people have that question and don't understand why there needs to be a financing statement filed against them in the context of the supplier. I'm going to move up to performance guarantee. Another fundamental component of these transactions is that there are often a number of different sellers. Those sellers can be in a number of different jurisdictions. Obviously, the number of jurisdictions makes transactions or can make transactions more complicated. But because there may be a number of different subsidiaries of a parent company, all of whom are operating entities that generate goods, the sale of which creates the receivable that is sold, the bank or financial institution purchasing the receivables wants some comfort that there is a person at the top of the house who will be responsible for the obligations of the sellers, including their indemnity and repurchase obligations. It is important to note that these performance guarantees are not designed to be credit recourse. They are not designed to be guarantees by some parent company or any entity involved in the sale of the receivable that the account debtors will actually pay on time. As a result, sometimes instead of calling them parent performance guarantees, they're sometimes termed parent undertakings. What they are designed to do is, again, to satisfy the obligations of the subsidiary sellers in the event that there are circumstances where there is recourse to those sellers. For example, if receivables are not eligible on the date that they're sold, or if the receivables or the goods relating to them are dented. Again, we've talked about this a little bit, but there can be more sophisticated documentation depending on the nature of the transaction, whether or not it's a cross-border transaction, the type of receivables involved. LSTA concepts are becoming more common. It just means that there are some more standardized provisions in these documents, but again, they're receivables type provisions. Moving on to the next page, I know we're sort of working at a rapid rate here, but we do have quite a bit to cover, and obviously Massimo and I are available, or any of your friendly neighborhood Mayor Brown lawyers who you'd like to pick up and call after this webinar in the event that you have follow-up questions. You will have a copy of these slides, and so happy to talk to you after the seminar. Really important part of the diligence process and structuring process in a properly structured transaction with respect to the transfer of receivables is the cash management system. This is really something that needs to be reviewed up front. Questions need to be discussed up front. Where are bank accounts, for example? Sometimes these are things that people don't think about until later in the transaction, and they can create problems. Segregated bank accounts, where the account debtors pay the receivables, matters. The purchaser wants to know where its money is. The purchaser wants to be able to identify and trace the money coming in. There are a couple of ways that cash management systems can be structured, and some of this depends on the quality and the relationship between the supplier and the purchaser of receivables, and also just the specific facts and circumstances of each particular transaction. Obviously, a best-case scenario would be that collections come from the account debtors directly to the bank or the purchaser. This is obviously not always possible. It's not always efficient, and it's not always something that can be done under the circumstance because of the widespread nature of where the account debtors are and where they pay. It just wouldn't be efficient. As a result, a second step would be we know where the accounts are, we know that they are accounts of the seller, and we have dominion over those accounts in the form of an account control agreement. Under the UCC in the U.S., control of a bank account through some sort of a tri-party agreement with the bank, where the bank agrees to take instruction, they acknowledge the security interest, and they agree to take instruction from the purchaser at some point potentially in the future or starting at day one, that creates a security interest. It establishes not only the creation of a security interest, but also the simultaneous perfection of a security interest in that bank account in favor of the bank. Sometimes, however, this is not practical, and instead banks and purchasers get comfortable with the idea that money will go into a sometimes segregated, sometimes commingled bank account of the supplier, sometimes multiple accounts, with the idea that those monies should be swept to a purchaser-controlled or a purchaser-owned account within a short period of time. 1 day to 5 business days is fairly typical. 2 is usually the mark that most people land on. One of the things that you have to consider is if you don't have dominion over an account, if it goes through a seller commingled account, there is the possibility that, and there's the likelihood, in fact, that if the seller goes into bankruptcy, any money that rolls into that account is going to be subject to the automatic stay, and the purchaser is going to have to demonstrate why and how those collections should be transferred to the purchaser under those circumstances. There are other tools in the UCC that will help protect the purchaser in these circumstances. For example, once an account debtor is notified that the purchaser has purchased a receivable and received sufficient evidence thereof, that account debtor can only satisfy its obligation by making direct payment to the purchaser. Could be impractical in some circumstances when you're talking about 30-day receivables, but again, it's important to properly structure documents, properly put provisions in transactions that are intended to protect both the seller and the purchaser, and making sure that at the jump of a deal, everybody knows what they're getting into. Again, that's one of the things I urge in all of these transactions. There obviously are situations that create risks and potential pitfalls in every transaction, but going into the deal with a list and understanding what the risks are and making sure that they're appropriately communicated internally at both the seller and at the purchaser is an important part of every transaction. Let's move on to participation agreements. Again, we can quickly talk about participation agreements. It's a very typical form of risk sharing and risk allocation in these types of transactions. We're seeing a lot more interest from people other than the traditional parties who used to buy participations. It's not just banks anymore. Insurance companies and other finance providers are involved. Participation agreements are fairly standardized in the U.S. and abroad. They can be called different things, and they may have some different legal effects. But the general nature of a participation is that the lead bank remains the entity that has the relationship with the seller. The lead bank generally controls the transaction and how funds flow once they come from the seller in its capacity as servicer or otherwise to the bank. They are generally designed to be, quote, true sales or true participations, which can be done for both bankruptcy purposes or receivership purposes if we're talking about a bank as the lead entity, and from an accounting perspective. But again, from an accounting perspective, the transaction has to be structured properly in order to make sure that you receive the appropriate FAS 166 treatment in order to get off balance sheet with respect to that particular participation as between the lead bank and the entity that's buying the participation. It's important to note here, and we will do this later on when we talk about true sales, but you can have a situation where you've got a transaction that satisfies accounting sale treatment but doesn't satisfy bankruptcy sale treatment, and the other way around. You could have a transaction that satisfies bankruptcy true sale for legal isolation purposes, but not necessarily accounting true sale. One of the features of a participation agreement, I'm sort of skipping some of these because I'm consolidating them as we go, but again, happy to talk in more detail after this event if you have any questions or follow-up questions. One of the fundamental and important aspects of a participation agreement is that there are typically more limited rights of the participant than you would otherwise see in, for example, a broader loan syndication. And when I say more limited, I mean less rights. This partly is the result of just the customary and historical practice of trade finance and how these participations sort of came into existence. It also relates to the fact that these are short-term receivables, often paying within 30 to 60 days. There's really not a whole lot that the other participants could do other than potentially confuse and cause a lesser likelihood of collection on receivables when certain things are going bad. But you can imagine that the very typical limited rights that participants do often get in these transactions are, we won't reduce your principal balance, we won't change the interest rate, and we won't extend the tenor of the amounts payable to you. It is incredibly important, again, to note in participation facilities when you are the lead bank that you want to limit your potential exposure to the participants. The lead banks are generally not viewed as fiduciaries, and we go through great lengths to make sure that we're not viewed as fiduciaries. Now, what does that mean? That means making sure that the participant has received enough information and acknowledged that it has received enough information to conduct its own due diligence and make its own credit decision with respect to entering into the transaction. There is certainly a fine line between how much information you want to give the participant, how much control you want to give the participant, because the more you do so, the more you limit the likelihood that the participant is going to say they didn't know what was going on and therefore try to bring an action against the lead bank. But again, making sure that the document is properly structured, includes proper provisions protecting both the participants and the lead bank under various circumstances is incredibly important, because there are a lot of pitfalls that people can run into when aspects of the relationship are ambiguous as a result of the nature of the participation. And what, Massimo?
All right, so I'm going to very quickly have a small discussion on some accounting considerations, and these, for purposes of this discussion, means accounting considerations for the seller of the receivable. So you know, if you're on the phone and you're from a bank, this is the customer, not you. But really, and we're not, I mean, obviously we're not accountants, and I have to throw out the typical disclaimer that we're not qualified to provide accounting advice. But very briefly, we thought it would be helpful to have this slide because it's going to sort of parry into the slides right after this that are going to cover legal true sale. So you know, for accounting purposes, and this is really FAS 166 or ASC 860, there's really, for trade accounts receivable, there's really a three-part test to achieve legal off-balance sheet treatment, meaning that, you know, the asset, the receivable comes off the books of the seller and goes on to the books of the buyer. The first element is legal isolation. I'm sorry, these are all covered. The paragraph numbers of 166 are listed in the right after the items, and you can look it up if you'd like. But the first element is legal isolation. And that gets a little complex, but for our purposes as lawyers, the most important thing is that under U.S. GAAP, the accounting rules essentially require that in order for the seller to meet the 9A requirement, that there be a true sale opinion from a law firm. And this is like really the main reason that accounting and legal kind of get tied together, but it's difficult to satisfy 9A without a true sale opinion. And I think that's really the most important thing for us to say on that item. Number two is free assignability. So it's important when you're purchasing these receivables, and it's important for the sellers to understand that, you know, unlike a loan agreement, you know, or at least a middle market style loan agreement, you can't really give the seller as many rights to control, you know, to whom you as the purchaser, if you are the purchaser, is assigning the receivables. You know, it's an element that, you know, there is a little bit of spotty review on this amongst the accounting firms we find. We find that some auditors really focus on this and some don't, but really it's important to have the right to pass these rights on to third parties, at least, you know, subject to somewhat minimal restrictions. I mean, you won't be giving the seller the kind of rights that you might give them in a loan. And then three is no effective control, and what that really means is that even though you've purchased the asset, the seller can't, you know, control what happens with the asset after the sale. So, I mean, the most obvious example is that the seller has a right to repurchase the asset unilaterally, you know, and even worse, you know, for the price that you paid them. I mean, and I think that's all we really need to say about the accounting treatment, just other than to reemphasize what Dave said a little while ago, is that these really are two separate tests. Sometimes as lawyers it's hard for us even to kind of remember that, but you can come up with a number of scenarios that would be that would satisfy 166 and achieve, you know, off-balance sheet treatment, but still wouldn't be a true sale, and vice versa. The vice versa is actually probably more common than the former, but you can certainly do the latter. And with that, I'm going to pass it on to Dave, who's going to talk a little bit about but we're going to skip through these accounting slides because we're going to run out of time, but they'll be in the deck and they'll cover in more detail what we just discussed. But Dave's going to talk about legal true sale, and with that, I'm going to pass it on to Dave.
Thanks, Massimo. One thing back on accounting, just to mention it, right, but it's too much to go into in this presentation, but I do want to mention it. Obviously, there are transactions that fall under trade finance that aren't the sale of receivables. They deal more with relationships between a finance provider and a buyer of goods, payables transactions, and there are accounting considerations in those transactions that obviously need to be thought through as well if you come up into one of those transactions where you need to think about it. Again, accounting considerations have to and should be discussed between the counterparty, the party other than the bank, who's either financing payables or selling receivables, and their own accountants. Obviously, we're not accountants. We understand some of the topics. It's also important to note that the banks that are purchasing assets or providing financing are not accountants either, and they should be making sure that they say to their customer that their customer should be speaking with their accountants and tax advisors, of course. I know I burned through the first set of talking about documents at a pretty quick pace. Hopefully people's ears aren't burning, but we're obviously trying to get through this in time, and we're happy to talk in much more detail afterwards if you have questions and want to talk to us. So One of the fundamental, again, very important parts of transactions like this involving receivable sales is that the sale be a true sale. There's a couple of reasons for that. If the sale is a true sale from a bankruptcy perspective, again, going back to accounting, that's something that helps the accountants get comfortable with their legal isolation analysis for purposes of determining whether the transaction is off balance sheet from the seller's perspective, but more importantly from the buyer's perspective, a true sale from a bankruptcy point of view helps the buyer get comfortable that in considering the credit of the transaction and ultimately therefore the purchase price that they're willing to pay for the receivables, they don't have to consider the seller's bankruptcy and the seller's potential bankruptcy risk. Because if the assets are sold in a true sale that's been properly prepared and documented, if the seller becomes the subject of an insolvency, the receivables that are sold and therefore the collections relating thereto will not be part of the seller's bankruptcy estate. Again, there are some complications and caveats and complexities to deal with in that general statement, going back, for example, to whether or not there are commingled bank accounts that, can create some issues as to whether the bank account itself could be subject to the automatic stay. But as a practical matter, a legal true sale from a bankruptcy perspective allows the purchaser to look at the credit of the account debtor when determining what the appropriate purchase price for those receivables are rather than the credit of the debtor. It also obviates the need for some of the much more complicated covenants that you would expect to see in, for example, a revolver or a loan facility that have 15 pages of financial covenants and termination events relating to the same. So what is or what constitutes a legal true sale? Oh, by the way, this is a good point. Next page, Massimo. A legal true sale means that you've transferred the benefits of ownership and the risk of loss. One of the fundamental components of determining whether or not you've transferred the benefits of ownership and the risks of loss is what the intent of the parties is. Have you described in your agreement that you're intending to transfer the receivable in a sale? If you're intending to transfer the receivable as a sale and your documents are littered with words like debtor and secured party and borrower, your documents probably aren't in the best structure and the best form to be able to present those documents as something where you truly intended to create and evidence a true sale. I'm not saying it's not possible, but again, considering what the documents look like is an important part of structuring transactions properly, because we've probably all seen transactions that were designed to be sales, but people use terminology that made you scratch your head a little bit. In order to determine whether or not a transfer satisfies what is generically viewed as the law with respect to true sale, and I say generically because when we analyze these transactions and when we receive and deliver true sale opinions from a bankruptcy point of view, we analyze the law in various states. That's because although bankruptcy is a federal law concept, the determination as to whether or not a receivable was sold is a state-by-state concept. Bankruptcy courts are, of course, courts of equity, as noted on this slide. They don't have to follow precedent necessarily. They're determining what they think is the most appropriate and equitable under the circumstances, and so obviously the better drafted a document, and the better drafted in the sense that it truly evidences what is intended to be a true sale and doesn't have potential pitfalls that we can talk about later, the more likely you are to be able to make a convincing argument that your transaction did in fact satisfy the legal true sale requirements from a bankruptcy perspective. Also, I think we can go to the next slide. So, true sale primarily means that, again, you've transferred the benefits of ownership and the risk of loss. One big part of that and one fundamental component of that is whether or not you've transferred the credit risk, right? In these transactions, they're designed to be transactions where the buyer understands that they are taking the credit risk of the account debtor. The buyer realizes that if the account debtor goes insolvent or fails to make a payment as a result of its inability to make payments generally or its lack of financial wherewithal, that is a risk that the buyer is taking, and that is a risk that the buyer is incorporating into its calculation of the discount margin for purposes of the purchase price calculation. What the buyer is not generally accepting in transactions such as these are things for dented goods, right? Dilution, disputes, things where the receivable wasn't exactly what it was intended to be or represented to be from the start. There are forms of credit recourse that are appropriate and forms of credit recourse that are impermissible, or recourse in general. If a receivable wasn't eligible on the date that it was sold, that receivable can properly be put back to the seller and put back to the seller in a way that doesn't potentially violate the true sale nature of the transaction. Similarly, there are indemnities that are properly recourse back to the seller that don't violate the true sale nature of a transaction. And these are because these are things that the parties bargained for. If a receivable isn't eligible on the day that it's sold, the recourse in that circumstance is not recourse as a result of the lack of creditworthiness of the ultimate account debtor, but rather because the buyer didn't get what it was bargaining for. I'm going to move to the next slide and we'll try to follow the slides more closely again, but want to get through some of these just general overriding principles. A guiding principle, again, but not the end of the story, is the intent, as we mentioned, should be expressly stated. The intent should be reflected by the language. Limited control by the buyer and excessive control by the seller can evidence an intent not to sell the assets. Now, we know in these transactions that the seller is typically the servicer because it's in the best position to do so, and in fact wants to do so because it wants to maintain its relationship with the account debtor and not necessarily have the account debtor, remember we talked about non-notified deals, think that there is a problem with that seller's or the supplier's ability to continue to perform its role as an ongoing business. The control by the seller doesn't necessarily cause the true sale to be affected. It's a factor to consider, but it's not dispositive. Moving on, the seller should not have a unilateral right to repurchase. Some of these things are things that are obvious, to sort of all of us who work in this space. There are exceptions to every rule, right? There are circumstances where some limited right to repurchase that is a right and not an obligation, can be something that people look at and get comfortable doesn't necessarily violate or destroy the true sale nature of a transaction. All post-sale transfers back to the buyer must be made at fair market value, should be made at fair market value. Again, though, this is only in circumstances where the buyer comes up to the seller comes up to the buyer and says, we'd love you to sell these receivables back to us because we think we've got a better place to put them. This is not a circumstance where, for example, the receivable wasn't eligible on the date that it was sold. If a receivable isn't eligible on the date that it was sold, the repurchase price is typically calculated based on the original purchase price. The buyer should have the right to remove the seller as servicer, right? This is just demonstrative of having an ownership interest in receivables. And the commingling of collections, as we talked about earlier, is not a good fact from a bankruptcy perspective in terms of the analysis for true sale, but it's not necessarily dispositive either. It happens all the time. Usually you mitigate the risk by having a very limited time frame with respect to which the seller is able to commingle assets in its own accounts, whether those accounts are commingled or whether they're segregated accounts. Guarantees, like we talked about, performance undertakings, these are generally okay, and it's important to understand nomenclature, right? These are not guarantees of indebtedness. They are not guarantees of whether or not the account debtor is going to pay or doesn't pay because the account debtor is insolvent. They're generally performance guarantees of the obligations of the sellers and or servicers in the transaction that are obligations creating permissible recourse, indemnity obligations, obligation to repurchase receivables that weren't eligible when they were sold, disputes, dilutions, things like that. These are covered by typically some parent that has financial wherewithal, in an amount greater than its operating subsidiaries who actually generate the goods that are sold to create the receivable. Sometimes these are called performance undertakings because people just prefer that optically, but it's the same thing. Puts, right? Puts are where the buyer has a right to put receivables back to the seller. These are a bad fact from an analytical point of view, from a bankruptcy perspective, as long as they are puts in circumstances where, again, permissible indemnities, permissible recourse, repurchase obligations where receivables weren't eligible. Those are typically puts that are not something that would interfere or interrupt the true sale nature of the transaction, but just the straight obligation on the part of the buyer to put receivables back to the seller under circumstances where the receivable was perfectly healthy and eligible on the day that it was sold, is a fact that is largely inconsistent with the concept of a true sale. Here are some potential hidden forms of credit recourse. Again, a lot of this can be mitigated through proper drafting, and it's important to look at the documents and consider what provisions are built into the documents, because often we see provisions that parties either didn't intend or they put in, and sometimes without necessarily considering overall the bankruptcy analysis and how those provisions might affect the bankruptcy analysis. For example, when there are provisions where ongoing reps and warranties that have nothing to do with the eligibility of a receivable or the character of a receivable on the date that it was sold, the breach of which can create repurchase obligations, is obviously a fact that is a bad fact inconsistent with the true sale nature of a transaction and has to be analyzed more specifically. Now, of course, it can be perfectly appropriate if these breaches of reps and warranties relate to a servicer and its obligations to deal with and manage a receivable, and the breach of which results in the incollectability of the receivable or a lesser ability to collect that receivable. Well, they can be perfectly appropriate forms of recourse. Two was indemnities for credit recourse. I mean, that's obvious. You shouldn't have a catch-all indemnity that captures credit recourse. And in certain circumstances, in most cases, the servicing fees in these transactions are built into the purchase price and the discount margin. Sometimes they're stated specifically. That it's an issue that should be discussed between the parties, because lack of a servicing fee or a subordinated servicing fee can often complicate the true sale bankruptcy analysis. Talked about this earlier. I know we covered some topics earlier that are here later in the slides, and we're happy to talk about them later with you as we've discussed. Dilution, these are credits, rebates, credit memos, write-offs, things that are in the seller's control that the seller does, in its capacity as seller or servicer to manage the relationship between itself and its customer, where its customer is unhappy, maybe not unhappy because the goods weren't what they were described to be when sold, but maybe just unhappy, or maybe just part of a program that if you pay on time for this period of time will reduce the amount that you owe. These are not things or factors that the purchaser is considering as it makes its purchase price decision, and therefore dilution is perfectly appropriate. It's not credit recourse. It's something that's well within the control of the seller or the servicer. Similarly, disputes, whether or not bona fide, disputes that, for example, the goods were defective when sold to the buyer of goods, and the buyer of goods therefore, offsets or has, some level of discount as a result of the fact that the goods weren't what they thought they were going to get. Is, again, another appropriate form and very customary form of recourse that bankruptcy lawyers all over are comfortable. Again, as long as properly drafted, do not interfere with or diminish the strength of the bankruptcy analysis. The purchase price is something that should be determined at the time of sale. There shouldn't be retroactive adjustments in the purchase price. That's obviously a bad fact. Purchase price of future receivables should not be something that can be unilaterally changed by the buyer. Again, though, in the context of future receivables, as long as the purchase price is prospective and not retrospective, people can get comfortable with different transactions. Sometimes the parties say the purchase price will be whatever we agree to on the date that we sell the asset, and as long as it's two people coming together making a prospective determination of the purchase price, that's something that's generally consistent with a true sale. Moving on to the next slide. The buyer of receivables must bear substantially all the upside and the downside. That means that, and again, I'm going to sort of go through this list quickly, the purchase price mechanism shouldn't contain any sort of profit sharing, meaning if I collect over a certain amount with respect to this receivable, I give something back to the seller. That's basically the same as the second bullet point there. The seller being responsible for delay risk in all circumstances. can be something that has to be reviewed. Again, none of the facts necessarily on this list are dispositive and will destroy a true sale, but they are things that certainly need to be considered and looked at more closely. The last item on the list obviously is one, that would certainly be detrimental to a true sale and bankruptcy analysis in that respect. Something where you've got like an 80% advance rate, and we only pay you the rest of the purchase price if the receivable actually collects, is certainly a bad fact and much more indicative of a loan than a sale. Now, there are certainly transactions that have deferred purchase price or delayed purchase prices, but those are often designed to cover the potential for recourse that is permissible, for example, dilution and disputes, but that at some fixed date, the remainder of the purchase price is due and payable regardless of whether or not the receivable collects.
And Dave, I think that's a great point, because I think sometimes people really confuse, and we have a transaction where we're doing this right now, where people confuse dilution reserves with credit reserves.
That's right.
And dilution reserves generally okay, but only if it really is just meant to cover dilution, so rebates and stuff.
And the same is true. Many of these transactions have additional security for receivables that are not sold under the facility, and that additional security is designed to cover indemnity, dilution, things that are permissible forms of recourse.
Yeah, and that's a wider topic that we're not going to cover today, but a lot of these additional features we're seeing more and more in the U.S. market, because really they're bleeding over from maybe an Asian type model or a European model, where those types of additional aspects have been more common than they have in the U.S. in the past.
Yeah, that's right. And we also haven't focused on transactions that are cross-border transactions, which we're seeing much more and more recently. And usually the structure of those transactions, not usually, in many cases, the structure of those transactions where you've got multiple sellers, and I don't want to skip too far ahead because I know this is on the next slide, but the structure of those transactions can involve multiple U.S. and non-U.S. sellers that are party to a New York law governed document. So I think that's maybe most of the true sale issues here. I know that I sort of burned through that at the speed of light. The scratchiness in my throat tells me that. I apologize to any of you again, who had to listen to me ranting for that long a period of time on a particular set of topics. Hopefully I didn't go too fast and you got the flavor of it. And again, as we've said all along, we're happy to talk about these in more detail at some point of your choosing later.
And I'm going to bore you even further, because I do want to say one very brief thing on true sale, because a lot of times when Dave and I give this presentation, it's the first thing we say, and that's on that topic. There are very, very, very few things that we can point to when clients call and they want to know, is X okay? That's usually the question. There are very few things that we can point to and say, this is definitely not okay, right? Because true sale analysis, like we started at the beginning, it's an equitable analysis of the facts and circumstances, the substantive facts and circumstances, which is different in U.S. law than a lot of other jurisdictions. Really, the courts do look at the underlying substance of the transaction, and they look at it in total. So, whereas one particular feature may not in and of itself, cause a concern, if you have 30 of those features, right, maybe it does cause. I mean, it's really just a holistic analysis, and people don't like that answer because it doesn't create a lot of certainty, but it's sort of the system that we have here in the U.S.
Yeah, let me actually mention one more point. I think that's really important on that, and it's I'll state it quickly, but again, as we sort of said earlier, a true sale transaction is not necessarily the holy grail. As some of these transactions have more recourse than appropriate, and people go into the transactions knowing that the true sale is potentially compromised, but the costs and benefits, as analyzed, are something where the business people get comfortable that they're comfortable moving forward. It should certainly be a topic that's discussed very early, but as we know, there are many transactions, right, in the lending world that are not true sales, and people get perfectly comfortable and they're priced appropriately, and the parties understand whose credit risk they're taking and who they have exposure to, and so it's perfectly appropriate to have a transaction that's not a true sale, as long as it's something that the business people talk with the lawyers and talk with the internal credit folks about, and you make sure everybody's on the same page. We are not here to stop deals, right? And none of you participating in this webinar are here to stop deals. We're here to make deals work for the parties involved in a way that most closely aligns with the strategic goals and the economic goals of the parties. And so we're certainly here, and we all want to be as flexible as possible, but making sure at the same time that everybody's going into it with their eyes open. And as long as they're doing that due diligence up front, and people understand the nature of the transaction and what the risks are, we've all done our jobs.
All right, so we do want to take a few minutes, whatever time we have left. We do want to cover cross-border transactions a little bit, and I mean, obviously we're not going to do this any justice in a few minutes, but we do want to at least give you a flavor of this, and we're, like as we said about everything else, we're happy to talk to anybody who has any interest in more detail. We have, I'm sure we have another slide deck somewhere with about 60 slides just on this. But first of all, I think this first slide's overall is important. When you're talking about non-U.S. receivables, I mean, I think it's important to remember some of these facts. First of all, I think people very commonly forget that the European Union is actually made up of a lot more than a lot of individual countries. They each have their own laws, and they're not very uniform. So what may be okay in Spain is not okay in Italy, is okay in Ireland, and if you're really paying attention, that map of countries actually has countries on it colored that aren't in the EU, but we'll skip that for now. Another thing to mention is that it's important to remember that common law, which is used in the United States, UK, Commonwealth countries like Australia, New Zealand, it's more of a principles-based, pragmatic system. In one hand, we find, at least I believe, since I'm an American-trained lawyer, that it's much more flexible than the other types of systems, but the downside is that there aren't a lot of absolute answers sometimes, and I'm sure everybody on this phone has gotten frustrated speaking to someone like me when you call and, present some facts, and the answer we give you is, well, it sort of depends. But it really does. Contrast that with a civil law type system, which is common in continental Europe, Mexico, Japan. Those systems much more formal, easier to come up with an answer a lot of times, sometimes harder to actually do what you want. Fundamentally, the theory, in a U.S. style system is, as a individual contracting party, you can do pretty much anything you want so long as the law says you can't. In a civil law system, I mean, this is a gross overgeneralization, but it's fair to say, I think, that the way the law works is you can't do anything unless the law says you can. So that's why in a lot of these jurisdictions you'll find something called a securitization law or a factoring law, right, which will set out what it is you need to do to actually comply, which we just don't have in the U.S.-style system. Two, I think it's important to note that especially in this area, the U.S. bankruptcy system is not a common system, style system is not a common in the world. Most jurisdictions do not use the kind of system that we do here, which tends to be very debtor-friendly. The effect of that is twofold. One, I mean, it might be good for companies, but it creates a lot of uncertainty, and I think a lot of non-U.S. participants, when they're doing U.S. transactions, are very uncomfortable with the idea that you can't tell them up front with any kind of real certainty what would happen in a bankruptcy process. And also important to remember that a lot of U.S. concepts like true sale that we just talked about just don't exist in other jurisdictions. And they don't exist because there's no concept of there's no right to sell receivables, or more, sometimes there's no distinction that we have in the U.S. between a security interest and a sale. In some jurisdictions, they're treated the same. But it's important to remember that a lot of the terms we use every day just don't have any application in some places. And also remember that the reason legal systems exist, especially around in the area of debtor and credit, I mean, it varies a lot by jurisdiction. You know, in some places the laws exist, you know, fundamentally on a very broad level to protect debtors, and in some places they exist to protect lenders, and some places they exist for other things, but it's important to understand that context. All right, just very quickly going through the slides, there are a lot of issues that you need to consider when financing foreign receivables that we don't really think about much in the U.S., the most obvious of which is that, you know, in the United States, it's relatively easy for a financing or investor to purchase accounts receivable, because, you know, the main reason being that under the Uniform Commercial Code, it's not, you know, restrictions on assignment of receivables aren't enforceable. So that's not the case in a lot of other jurisdictions, so you know, there's a lot more diligence that's involved, because it could be the case that the person selling you the receivables has no rights to do so, and it's totally enforceable and your purchase is void. You know, there could be capital controls depending on the jurisdiction you're involved with. I mean, that's something you want to think about right away at the beginning. It could be the case that in some countries you just can't effectively do this. Finally, corporate issues. You know, in the U.S., we tend to really gloss over these kind of issues. I mean, we try to do some diligence. We get some documentation for things like corporate governance, authorization, that kind of stuff. But in some other jurisdictions, especially, you know, in Latin America, Russia, some East Asian jurisdictions, these are really important issues, because the formal documentation requirements kind of trump everything else, and there are definitely places in the world where your documents could say whatever it is they need to say. They could be negotiated and signed by whoever it is the appropriate person, but if step 6 in the corporate approval process wasn't taken, or the approvals don't have stamp Y or whatever, your sale isn't effective and there's nothing you can do. Clearly in the U.S. that burden really shifts to the seller. In some other jurisdictions, it's the bank's burden to figure out. There's a lot of enforcement practicalities when you're trying to finance receivables overseas, and both from sellers and account debtors. You know, really obvious issues. You know, are you going to be able? All your documents are probably going to be governed by U.S. law, but are you going to be able to sue the company in the U.S.? I mean, do they have a presence here? You know, do they have any assets that you can take? If not, how are you going to enforce your rights? You know, if you get a judgment in New York, will country X recognize it? If you don't, if it won't, do you need to sue them in country X? If you sue them in country X, will your documents be, you know, recognized under foreign law? There are plenty of jurisdictions in the world where they do not recognize U.S. judgments. So if you want to collect on a contract, you need to sue the counterparty in their jurisdiction, which, you know, on things like these types of transactions, it's important to make sure that your document, even if it's governed by New York law and the country will use New York law, that you comply with whatever formalities are required in that jurisdiction, because that could cause your contract not to be enforceable.
Yeah, I should just butt in for 1 second, because this came up recently, Massimo. Someone asked whether or not PDF signature pages are appropriate evidence of contract formation. You know, if we don't have wet ink originals, for example, will that work? And in the U.S., there are not only federal evidentiary rules, but other rules and case law, you know, that generally say, you know, a PDF copy is an admissible form of evidence to determine whether or not the parties agreed to a particular contract. And that question then was, does that apply in all jurisdictions all around the world? And the answer to that is, it does in many, but not in all. There are some jurisdictions that will require more formalities, and including that in some cases wet ink signatures be filed with certain government agencies.
Yeah, absolutely.
So it's absolutely critically important in a cross-border transaction to understand the formalities in the law in the jurisdiction that you're working.
Very quickly, a note on licensing. Remember that a lot of jurisdictions in the world regulate factoring. You know, you need a government license, or you need to have some sort of exception, either to do the deal to begin with or to enforce. And I'm going to skip through most of the rest of these because we're over time. But just once again, emphasizing what we just said, if you're dealing with a foreign entity, it's a very good likelihood that your rights and your contracts are going to have to be enforced locally in the jurisdiction. So please think about that when you're, negotiating your documents. And then finally, one really practical point on cross-border stuff, sometimes it just doesn't make sense to engage in all of it. We get a very common ask we have all the time is, hey, we're generally financing U.S. receivables. We'd like to include, country X. And can you do country X? And yeah, we can, except that the cost of doing country X is so high relative to the flow of receivables that you have that it just doesn't make any sense. And finally, just a very quick note, and I always use this slide in presentations because I think it's really indicative. I always tell people, anytime you're doing a transaction that involves people outside the United States, just because everyone uses the English language or Chinese or whatever language everyone is speaking on the phone, or Spanish, remember that doesn't necessarily mean the same, terms and phrases don't necessarily mean the same thing to everybody. And I love this slide. I use it all the time because it says two nations divided by a common language. But I always tell people if English people and Americans can't use the same words, you're not going to have a lot of luck with people from 16 countries all speaking English on the phone and not coming away from that conversation with at least some level of confusion. That's all we have. There's a slide that says questions, but if you submitted one on the WebEx, we will get back to you. Thank you for putting up with us. We're happy to speak with you anytime.